Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but also how we're going to fix it together. Now, before we dive into the topic, how do you guys like these sunglass sunburn eyes right here? I came dressed for the internet, didn't I? Anyway, we're going to move on. So the content that we're going to talk about is what a federal judge did supporting the Illinois assault weapon ban. Now, this is massive. There are so many ins and outs, but ultimately, this just set up the biggest smackdown for assault weapon bans and magazine bans across the board federally, as high up as the SCOTUS very soon if this kind of stuff continues. Everything will be linked in the description box below, and if you are new or you're a returning viewer, please consider hitting that like button, subscribing to the channel, and making sure you got the notification bell on. We need as many of you as possible to jump into the fold, be counted amongst friends, and help pass the blessing of the Second Amendment along to the next generation. Thank you so much in advance for your consideration, and this content is brought to you by LAS Concealment. If you're in the market for a holster for your favorite freedom tool, LAS Concealment is worth a look. All of their holsters are made out of Kydex. They are form-fitted to each individual firearm. These things are incredible. They are snug and they are secure, and there's something for everybody in there. Whether you want something for inside the waistband or outside the waistband, they have been tested by the world's most elite special forces, and like I said, there is something for everybody. There's a link in the description box below, and thank you so much to LAS Concealment for making this content possible. But now, my brothers and sisters, let's dive into this because a federal judge has set up the ultimate destruction of assault weapons bans and magazine bans by violating these rights. This is incredible because they supported the Illinois assault weapons ban. Check this out. Everything's linked if you want to read the entire thing because this is important. Federal judge denies bid to block Illinois assault weapons ban and the Naperville gun restriction. Now, what they're saying is there's basically a challenge against the Illinois state assault weapons ban, and Naperville had some challenging provisions as well. The federal judge supported the idea that these cities and states can ban weapons outright, but the Bruin decision, because they're looking for support, wait until I show you what she actually did. This is where she sets up the ultimate defeat. Check this out. Let's keep going because this... A federal judge in Chicago, shocker, has denied a motion seeking a temporary restraining order and preliminary injunction to block Illinois' assault weapons ban and a similar ordinance in Naperville. U.S. District Judge Virginia Kendall ruled Friday that the Illinois and Naperville bans on selling assault weapons are constitutionally sound. Now keep in mind, the Bruin decision is looming really heavy here, and wait until I show you what she does with that. But it's also unconstitutional for many other reasons. Constitutionally sound, my foot. Anyway, let's keep going because this is where they start to set up the ultimate failure. In her ruling, Kendall wrote that the Illinois and Naperville bans meet the burden, quote, because assault weapons are particularly dangerous weapons and high-capacity magazines are particularly dangerous weapon accessories. Their regulation accords with history and tradition. There's the Bruin satisfaction in her mind. Naperville and Illinois lawfully exercise their authority to control their possession, transfer, sale, and manufacture by enacting a ban on commercial sales, the judge wrote. Now, the big problem here is she's trying to satisfy the Bruin decision. The only problem with that is she's completely negating the idea that common use, which applies to 25 million assault weapons, really they're called AR-15s, modern sporting rifles, in the United States. In trying to satisfy the Bruin decision, she just threw common use under the bus completely. Not to mention the fact that it's completely ridiculous. This is a political partisan reach right here. But let's keep going because this is how they will be undone because they do things like this. In that ruling, whose majority opinion was written by Justice Clarence Thomas, talking about the Bruin decision, restrictions on weapons must be limited to dangerous and unusual arms that aren't commonly used. See the twist? AR-15s or assault weapons or modern sporting rifles, whatever you want to call them, those are one of the most commonly used platforms in the United States. To rule them as dangerous and unusual would be trying to shove them into a category that would be underneath regulation. Do you see what she's doing? She's trying to reclassify something that's clearly under common use, and there are 2 or 3 different Supreme Court cases supporting the fact that they're common use. This is going to be the most slam dunk of slam dunks cases because they're stretching so hard. Let's keep going because this is really important. The weapons banned by the Illinois law are unquestionably in common use. The lawyers for the National Association for Gun Rights argued, and they're completely right. Listen to this exchange to wrap this video. Quote, an arm that is in common use for lawful purposes is, by definition, not unusual. The lawyers wrote, quote, such an arm, therefore, cannot be both dangerous and unusual, and therefore cannot be subjected to a blanket ban. They're right. Kendall ruled that the government can regulate highly dangerous arms, including assault weapons and large capacity magazines that pose an unusual risk that can cause greater harm and more deaths. That's interest balancing. The Bruin decision specifically said you cannot balance interest like this anymore. It is only history, text, and tradition. This whole two-step process of your rights are important, but public safety is more important, that's out the window because that's not constitutional. They are going to get smoked with this approach. Quote, the text of the Second Amendment is limited to only certain arms, and history and tradition demonstrate that particularly dangerous weapons are unprotected, the judge wrote. They are going after the unusual and dangerous approach when applying to one of the most commonly used platforms in the United States, with multiple Supreme Court cases supporting common use, because they cannot satisfy the Bruin decision without changing definitions to unusual and dangerous when it's clearly in common use. Are you guys seeing the writing on the wall on this one? Let me know what you guys think in the comments below, and I will see you on the next one. I'm Braden. See you later.